my own timer. Thank you, Madam Chair and Committee, and thank you for listening throughout the testimonies today. My name is Sheila Hemphill, and I'm testifying on behalf of Texas Right to Know and myself for 602, 603, and 604.
Thank you so much, and it's good to see you again.
Thank you so much. I have in front of you kind of a consolidation of my 2 years of investigating complaints that have been lodged against the Texas Medical Board. This is a self-initiated investigation because I'm all about trying to fix problems that have been identified, and you can't fix that which you're not aware of. So I started out by asking, how would one file a complaint against the agency itself? There was not a link on the website, nor was there a policy. So July 2nd of this 2018 is when the medical board did hear that information, and they issued a policy on how to complain against the agency. So in my research, because the board is appointed by the governor, I thought, well, maybe they have a complaint policy. But as you see, the reply back from my open record is right here. There is no formal complaint process administered by the Office of the Governor for complaints against the Texas Medical Board. So they didn't have a policy until July 2nd. So they are being compliant when you're finding these problems, so I appreciate that. However, if you look at what the policy is basically to complain about the agency, to be resolved by the agency. And to the agency's defense, the designated oversight of the medical board, get this, is the 181 offices of the Texas legislature. So there has never been one central office of an avenue for complaints to be lodged against the agency of the medical board, nor of the Board of Nursing. So when even a patient has filed a complaint against a doctor to the agency, if that complaint gets dismissed, there's nowhere for these patients to go to counter it. So what I find really disturbing is you heard since 2014, and here are a 5-year saga on Dr. Van Boven. There were no patient harm or complaints about the major ones. And yet, I'm now getting complaints from people about significant harming complaint to patients that just go dismissed. And I've got one very serious right now that was dismissed when the woman urinated within her cavity for 11 days. And when she complained to the medical board, it was just dismissed. When she asked why, the response was, we're attorneys and we're not doctors. Well, that gutsy woman found out how to appeal. She didn't appeal before an informal settlement conference, and she was not even allowed to have her mother with her. So here she was in front of the doctor. This is on her second of appeal. In front of the doctor, in front of the doctor's attorneys, and all the medical board attorneys, and I was asked to be a witness, which I was not allowed to even be in the room. Neither was her mother. So we've got problems with the protocols, and I'm not sure how much of that is rule problem or law problem. But when people cannot afford to have an attorney to help represent themselves as a defense, as a physician, or as a patient, they should be able to have an advocate with them. She had a stack of folders this big on her patient records. So in this document, okay, we talked about not being a complaint process. Now, my evening hours consist of reading transcripts and depositions of physicians' cases, and it's a good thing I started with physicians because they have more money to carry out these legal defenses, to go through informal settlement conference, the appeals to district court, and on to Fifth Circuit Court of Appeals. We've got 4 physician cases who are suing the medical board at the Fifth Circuit Court of Appeals for unwarranted search and seizure of patient records because all 4 of them had the medical board come in with administrative subpoenas with law enforcement in tow, either DPS or DEA agents or local law enforcement, 4 of them. All didn't know each other, and they all have identical situations. In the Zeta case, when it was announced by General Counsel Freshour, when they gave an update to the board about one of these federal cases, we won, right? Well, go look how they won. They won because the board is granted quasi-judiciary status. The prosecutors are quasi-prosecutorial, and they're subject to absolute immunity. Absolute immunity. The investigators are qualified for qualified immunity, which means you have to meet certain parameters to do it. Well, in one of the cases, in the Cotropia case, the Fifth Circuit ruled in favor of the defendant, of the doctor. The board is appealing it. And this is on the last page, and I find this quite disturbing. That it is because it is the job of the Attorney General's office to defend the agency. What they are proposing as a defense is to try to rule, this is number 5 on page 4. The Office of Attorney General is trying to appeal that the practice of medicine is a closely regulated industry. According to the Supreme Court, a closely regulated industry are liquor store sales, firearms dealing, mining, and running automobile junkyards, which means those records are subject to just state inspection without a subpoena or without a warrant. Now, this is contrary to the 2000 AG opinion by John Cornyn that says the medical profession, unlike the liquor industry, has no long history of warrantless state inspection. Rather, it is a profession with a history of respect toward the recognized need for privacy and doctor-patient relationship. So I have sent requests to the AG's office asking specifically if it is the intent of AG Paxton and the office to deem the practice of medicine a closely regulated industry. Because when you look at the rulings, this is what is being put forth by AG Counsel of Record John Sullivan, filed the appeal with the Fifth Circuit Court in the Zeta versus Robinson. But if the court were to what's the moral of the story? There's no oversight. There's nowhere for a central office to go to receive complaints by patients about their response from the medical board or the licensees, for doctors or nurses, which have recently contacted me. People are finding my website, and it's like I'm becoming the de facto ombudsman because there's no central office of where to lodge a complaint. To the medical board's defense, in a quote from Mr. Carlton, when I asked him, I said, Mr. Carlton, how do you expect there to be any integrity to complaint process if there's not an independent third-party review of the complaints? To their defense, he said he'd be happy to have a third party do it, but the legislature has never set it up. So really, this lack of oversight falls at the feet of the Texas legislature.
Members, are there questions? Ms. Hemphill, as always, thank you.
Thank you.
Darren